Hi, I'm Hasoon, a Senior Associate in the Employment team at Mills Reeve. In this vlog, I'm going to share some thoughts on the Court of Appeal decision in the case of Tesco v Union of Shop, Distributive and Allied Workers, or USDAW as the union is commonly referred to. The case itself relates to the practice of fire and rehire, and in this video I'm going to take a look at what the decision may mean for employers moving forwards. So firstly, for context, fire and rehire, or dismissal and re-engagement as it's sometimes known, is essentially the practice of forcing a change of employment terms by dismissing employees and then immediately re-engaging them on new terms. It's a practice which at times has attracted scrutiny from the media, public and political arenas. And in that respect, you may have seen the government announcement which followed the P&O story earlier this year, in which it confirmed plans to introduce a new statutory code of practice on fire and rehire. For this video though, I want to focus on the implications of the Tesco decision handed down by the Court of Appeal this summer. So if we start by looking briefly at the background to the case, in 2007 Tesco undertook a strategic reorganisation of its business which involved making some closures, relocations and focused on its distribution centres. As Tesco didn't want to lose all of its employees at its affected locations, it took the decision to offer staff an incentive to relocate. The incentive offered was called retained pay and was essentially an alternative to a lump sum redundancy payment. Now there's a few things worth pointing out about how the offer of retained pay was put to staff. Tesco communicated to staff that the retained pay would remain in place for as long as the employees remained in their current role, that it would increase each year in line with any general pay rise, and they also said it couldn't be negotiated away. Further to that, there were other statements and agreements released at the time which pointed towards the change in contract being a permanent feature of individual employment contracts. Fast forward to January 2021, and I think it's fair to say that the market conditions impacting Tesco's business were very different from 2007. As a result, Tesco made a proposal to remove retained pay from employee contracts and offered a lump sum incentive to encourage staff to accept the proposal. It decided that if an agreement couldn't be reached, it would consider dismissing and re-engaging the employees on new terms and conditions which would exclude retained pay. When Tesco then failed to obtain employee consent to the change, USDAW sprung into action and was successful in securing an injunction from the High Court for 42 of its members. The injunction prevented Tesco from removing the entitlement to retained pay by dismissing and re-engaging these employees. Tesco then successfully appealed that decision, with the Court of Appeal concluding that the injunction shouldn't stand. So if we take a look at the Court of Appeal's decision, it gives us an interesting insight into how the courts approach the interpretation of express and implied employment terms. Looking firstly at what the court said about the express terms, it found that despite terms relating to retained pay being referred to as permanent, that didn't override the notice provisions which allowed the business to end the contract in the usual way by giving notice. So essentially the right to retain pay would be permanent only for as long as the contract was still in operation. They also concluded that there didn't appear to be any reference or evidence that either party had thought about the practice of fire and rehiring when entering into the contract, nor anything to suggest the parties intended the contracts would continue for life. The court also examined the question of whether a term should be implied into the contract that prevented Tesco from firing and rehiring these individuals. So I think the first thing to say on this is that the concept of implied terms is common to all types of contract. In an employment context, a fairly obvious example is that of the implied term of mutual trust and confidence. It's also worth noting that there are a number of different tests the courts can apply as to whether a term is implied. Here I'm just going to touch on their approach to the obviousness test. So this test, also known as the officious bystander test, asks whether a term should be implied because it is so obvious it goes without saying. On this point, the passage of time from the introduction of retained pay in 2007 to the proposal to remove it in 2021 was a key factor in the court's decision making. The court considered that if Tesco sought to carry out the dismissals straight after offering terms which referred to language such as permanent, an officious bystander would have said it can't do that given the assurances it had given at that time. However, in their view, after a period of 13 years, they decided that the officious bystander would have considered the contracts can be terminated in accordance with the standard notice provisions, and so 13 years later on, the obviousness test was, in their view, not made out. Interestingly, the court also concluded that even if it agreed with the High Court's reasoning, an injunction was not the appropriate remedy. They said the appropriate remedy for wrongful dismissal, i.e. where someone is dismissed in breach of contract, was generally financial. So what are the implications of this case for employers? Well, I think the decision probably comes as a relief to most employers, most notably Tesco, who are no longer injuncted from proceeding with its business proposals. The High Court decision was the first whereby an indefinite injunction had been placed on a private employer, and so the Court of Appeal decision represents a significant scaling back from that position, and basically means that fire and rehire remains an option open to employers seeking to change employee terms. That said, employers should continue to exercise real caution when considering fire and rehire as a tactic. Tesco case was highly fact-specific, and there are still a number of financial risks which can arise out of deploying this practice, such as claims for unfair dismissal, wrongful dismissal, and even potential claims for failing to collectively consult where large numbers of employees are involved. The case demonstrates the importance of ensuring employment contracts are carefully drafted and highlights the importance of ensuring sufficient flexibility is built into employment terms. I don't think there's much doubt that Tesco had good intentions at the time of negotiating retained pay in 2007, but ultimately it set unrealistic expectations to staff and the unions in the language it used, which in turn created a significant problem for the business years later. If employers are negotiating new employment terms relating to things like bonuses or pay, should be looking to build flexibility into terms where possible and ideally consider setting a long stop date. It's also helpful to make it clear that such terms will only last for as long as the employment contract remains in place. Finally, it's also worth noting that this might not be the last we hear on this case, as USDAW has indicated it would take its case against Tesco to the Supreme Court. Overall, I think this signals an interesting time for the evolution of fire and rehire practices, and is certainly an area in which we are expecting to see some further developments over the next year.